Good evening, Father Dan. Good evening, classmates. I am Ken Brian A. Medalla, and our group will report on Chapter 5, Law and Equality, and I will discuss the principles of equality. The core of Aristotle's idea is that justice must be understood in the sense of what is fair and equal. Thus, he distinguished justice between proportional or distributive, wherein each man receives what he is entitled based on his ability and achievement, numerical or equality, wherein each man is counted for one and only one. This Aristotelian notion of justice is partly based on Pythagorean philosophy of justice, which is essentially requital, that is, compensatory of benefits and injuries which are inevitable in the relationships existing among individuals living in society. Its object is to render as nearly as possible what belongs to everyone according to the rule of law. These are the terms introduced under the principles of equality. First, simple equality, which refers to a state of affairs where everyone in a given society is given the same good equally, whereas egalitarianism is a school of thought that espouses equality for everyone in terms of fundamental worth or status, or simply the removal of economic inequalities. The application of equality in case law. This is the case of Garcia versus Drilon and Garcia on the constitutionality of the Anti-Violence Against Women Act under GR number 179267 dated June 25, 2013. Jesus is the petitioner while Rosalie is one of the private respondents. Factual antecedents. On March 8, 2004, Congress enacted RA number 9262 or the Anti-Violence Against Women and Their Children (BAUSI Act), which defines and criminalizes acts of violence perpetrated by women's intimate partners. Private respondent Rosalie filed a petition before the Regional Trial Court of Bacolod City, a temporary protection order or TPO against her husband, Jesus, under R8 9262. Rosalie claimed to be a victim of physical, emotional, psychological, and economic violence resulting from marital infidelity, threats of deprivation of custody, and financial support deprivation. The TPO was granted, but the petitioner failed to faithfully comply with the conditions set forth by the said TPO. Private respondent filed another application for the issuance of a TPO ex parte. The trial court issued a modified TPO and extended the same when the petitioner failed to comment on why the TPO should not be modified. The petitioner filed before the Court of Appeals a petition for prohibition with a prayer for injunction and TRO on questioning the constitutionality of RA 9262 for violating the due process and equal protection clauses, and validity of the modified TPO for being an unwanted product of invalid law. The Court of Appeals issued a TRO on the enforcement of the TPO but dismissed the petition, ruling that the constitutional issue was not raised at the earliest opportunity, and that is before the trial court, and that the petition constituted a collateral attack on the law. The petitioner appealed to the Supreme Court. The petitioner raised the following issues before the Supreme Court. First, did the Court of Appeals err in dismissing the petition on the theory that the issue of constitutionality was not raised at the earliest opportunity and that the petition constitutes a collateral attack on the validity of the law? Second, did the Court of Appeals commit a serious error in failing to conclude that RA 9262 is discriminatory, unjust, and violative of the Equal Protection Clause? Number three, did the Court of Appeals commit a grave mistake in not finding that RA 9262 runs counter to the Due Process Clause of the Constitution? The fourth issue, did the Court of Appeals err in not finding that the law violates the policy of the state to protect the family as a basic social institution, specifically on the non-referral to mediation? And the last, did the Court of Appeals seriously err in declaring RA 9262 as invalid and unconstitutional because it allows an undue delegation of judicial power to barangay officials? The ruling. As to the first issue, the Supreme Court held that the Court of Appeals correctly dismissed the petition for prohibition. Regional trial courts, including those designated as family courts, possess jurisdiction to resolve the constitutionality of a statute. This authority is part of the general judicial power to determine valid laws based on conformity to the fundamental law. The issue of constitutionality could have been raised at the earliest opportunity in the opposition to the petition for a protection order before the RTC. As to the second issue on equal protection, RA 9262 does not violate the guarantee of equal protection of the laws because it is based on a valid classification. Equal protection simply requires that all persons or things similarly situated should be treated alike, both as to rights conferred and responsibilities imposed. In the early case of Victoriano versus Elizalde Rope Workers Union, it provides that first, the guarantee of equal protection of the laws is not a guarantee of equality in the application of the laws upon all citizens of the state. Equality of operation of statutes does not mean indiscriminate operation on persons merely as such, but on persons according to the circumstances surrounding them. The equal protection of the laws allows classification. So what is classification? Classification in law, as in other departments of knowledge or practice, is the grouping of things in speculation or practice because they agree with one another in certain particulars. Thus, a valid classification must be based on first, substantial distinctions, second, germane to the law's purpose, and third, not limited to existing conditions and applicable equally to members of the class. On substantial distinctions, the classification rests on the unequal power relationship between men and women, the fact that women are the usual and most likely victims of violence, and the widespread gender bias and prejudice against women. Violence against women is considered gender based violence, a manifestation of the historically unequal power relations. Statistics show that female violence comprised more than 90% of all abuse forms and was committed by intimate partners such as their husbands and live-in partners. And addressing discrimination through specific measures focused on women does not discriminate against men. As Justice William McIntyre succinctly states, the accommodation of differences is the essence of true equality. On the German to the purpose, the distinction between men and women is germane to RA 9262's policy, which is to address violence committed against women and children, and in keeping with human rights instruments like CEDAW or the Convention on the Elimination of All Forms of Discrimination Against Women. The CEDAW is committed to condemning discrimination against women and directs its members to undertake without delay all appropriate means to eliminate discrimination against women in all forms, both in law and in practice. Known as the International Bill of Rights of Women, CEDAW is the central and the most comprehensive document for the advancement of the welfare of women. It brings the women into the focus of human rights concerns, and its spirit is rooted in the goal of the United Nations, that is to reaffirm faith in the fundamental human rights, in the dignity and the worth of human person, and in the equal rights of men and women. It explicitly acknowledges the existence of extensive discrimination against women and emphasizes that such is a violation of the principles of equality of rights and respect for human dignity. Also, the law is not limited to existing conditions and applies equally to all women and children who suffer violence. The law uses the gender neutral word person when referring to those who have a sexual or dating relationship with a woman, encompassing even lesbian relationships. The argument that the law removes the difference between violent action and simple marital tips is tenuous as the specific acts constituting VOC are enumerated based on research. As to the third issue on due process, the law is not violative of the due process clause. The essence of due process is in the reasonable opportunity to be heard and submit any evidence one may have in support of one's defense. The grant of the TPO ex parte cannot be impugned as violative of the right to due process. A TPO may be issued ex parte, which is from one party only, when the life, limb, or property of the victim is in jeopardy. This is justified because time is of the essence, and the ordinary requirements of procedural due process must yield to the necessities of protecting vital public interest, and that is the protection of women and children from violence. Also, the essence of due process is a reasonable opportunity to be heard, and this is afforded to the respondent. When a TPO is issued ex parte, the respondent must be immediately given notice and directed to file a verified opposition accompanied by witness affidavits within 5 days from service. The petitioner had the opportunity to file an opposition and a motion for modification, but failed to show sufficient cause why the renewal should be prevented. Also, the removal and exclusion of the respondent from the residence, regardless of ownership, is authorized only temporarily for protection or permanently only where no property rights are violated. As, the, as to the fourth issue on non-referral to mediation, the provision mandating that the court shall not refer to case or any issue thereof to a mediator is justified. This because violence is not a subject for compromise. Mediation of violence issues is problematic since it implies that victim is partially at fault, and also the victim is frequently unable to participate equally with the perpetrator due to unequal bargaining positions. And as to the final issue on undue delegation, there is no undue delegation of judicial power to barangay officials. The Barangay Protection Order or BPO merely orders the perpetrator to desist from causing or threatening physical harm. This function is purely executive in nature, consistent with the Punong Barangay's duty to enforce all laws and ordinances and maintain public order. The act of the punong barangay in determining the reasonable ground for imminent danger is analogous to a prosecutor conducting a preliminary investigation, which is an executive and not a judicial function. The conclusion: the Supreme Court denied the instant petition for review on certiorari for lack of merit, sustaining the constitutionality of RA 9262. To declare a statute void and an equivocal breach or clear conflict with the Constitution must be demonstrated beyond reasonable doubt. Also, the petitioner failed to present concrete evidence or convincing arguments to warrant a declaration of unconstitutionality against RA 9262. The law serves as a fulfillment of the struggle of women for equality, countering the historical tendency of the law itself to be a hindrance in the fight against domestic violence.
Good day, everyone. As for the next report, I'm going to be tackling rights and equality. Now, rights are fundamental principles of freedom or entitlement, either ethical or legal, that are either allowed to people or owed to them. Equality, on the other hand, is the principle of treating everyone the same and providing the same opportunities, rights, and status regardless of their personal characteristics like race, gender, or beliefs. While classical schools, such as the Greco Roman Aquinian perspective, considered that the moral nature of man as the starting point in the formation of the ideals of justice and equity to govern human conduct and expectations, the utilitarians considered the beneficial consequences of an act or rule as the measure of its goodness and value. Classical thinkers believed law must start from what is morally right because of human nature, whereas utilitarians, on the other hand, believed law must be judged by its practical results, whether it produces happiness and benefits for society. Utilitarians believed that the foundation of law should be its usefulness and consequences, and a law is just if it promotes the greatest happiness for the greatest number of people, making society better overall. Now, the Philippine Commission on Women explains that violence against women, or VOW, is not random and is rooted in gender based violence, meaning unequal power relations between men and women. Societal norms and traditions dictates stereotypes such as men are expected to lead, provide, and dominate whereas women are expected to nurture, support, and remain subordinate. This imbalance gives men greater social power, having violence against women be a form of men's expression of controlling women to retain power. The unequal power relationship between women and men, and the fact that women are more likely than men to be victims if violence and the widespread gender bias and the prejudice against women all make for real differences, justifying the classification under the law. Now, this dynamic illustrates that violence against women is not merely a private or isolated issue, but a structural problem rooted in inequality. It reflects how cultural expectations and social hierarchies shape conduct, reinforcing discrimination and subordination. In the context of rights and equality, addressing violence against women requires dismantling this unequal relations and ensuring that laws and policies promote substantive equality between men and women. And as the words of Justice McIntyre, the accommodation of differences is the essence of true equality. Stated in Article 2, Section 14, the state recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men. Now, our Constitution also mandates in Article 2, Section 14 that the state recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men. Similar to the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, which requires that the Philippines, as state party, take all appropriate measures to modify the social and cultural patterns of conduct of men and women, with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of inferiority or the superiority of either of the sexes or on stereotype roles for men and women. Now, the use of affirmative language should imply that in the proper suit, a declaration of unconstitutionality on, on the found of the equal protection should not automatically mean that the entire legislation that provides effective and efficient protection on women be set aside. Now, as the topic of rights and equality, we apply the case of the International School Alliance of Educators versus Honorable Leonardo A. Quisimbing, JR number 128845 on June 1, 2002. The facts of the case given is Private Respondent International School Incorporated, the school for short, pursuant to Presidential Decree 732, is a domestic educational institution established primary for dependents of foreign diplomatic personnel and other temporary residents. To enable the school to continue carrying out its educational program and improve its standard of instruction, Section 2C of the same decree authorizes the school to employ its own teaching and management personnel selected by either locally or abroad from Philippines or other nationalities. Such personnel being exempt from otherwise applicable laws that have been or will be enacted for the protection of the employees. The school hires both foreign and local teachers as members of its faculty, classifying that same into two. So, foreign hires and local hires. Should the answer to any of the queries point to the Philippines, the faculty member is classified as a local hire. Otherwise, he or she is deemed a foreign hire. The school grants foreign hires certain benefits not accorded local hires. This includes housing, transportation, um, shipping costs, taxes, and home leave travel allowances. Foreign hires are also paid a salary rate 25% more than local hires. The school justifies that difference on two significant economic disadvantages foreign hires have to endure, namely the dislocation factor and the limited tenure. Now, the school explains a foreign hire would necessarily have to uproot himself from his home country, leave his family and friends, and take the risk of deviating from a promising career path, all for the purpose of pursuing his profession as an educator. But this time in a foreign land. Now, the new foreign hire is faced with economic realities, decent abode for oneself and or for one's family, then effective means of transportation, allowance for the education of one's children, adequate insurance against illness and health, and of course, the primary benefit of a basic salary or retirement compensation. Because of a limited tenure, the foreign hire is confronted again with the same economic reality after his term that he will eventually and inevitably return to his home country where he will have to confront the uncertainty of obtaining suitable employment after a long period in a foreign land. Now, the compensation scheme is simply the school's adaptive measures to remain competitive on an international level in terms of attracting competent professionals in the field of international education. Now, when negotiations for a new collective bargaining agreement were held on June 1995, Petitioner International School Alliance of Educator, a legitimate labor union and the collective bargaining representative of all faculty members of the school, contested the difference in salary rates between foreign and local hires. This issue, as well as the question of whether foreign hires should be included in the appropriate bargaining unit, eventually caused a deadlock between the parties. On September 7, 1995, petitioner filed a notice of strike. The failure of the National Conciliation and Mediation Board to bring the parties to a compromise prompted the Department of Labor and Employment or DOLE to assume jurisdiction over the dispute. Now on June 10, 1996, the DOLE acting secretary Crescenciano B. Trajano issued an order resolving the parity and representation issues in favor of the school. Then Dole Secretary Leonardo A. Casimbing subsequently denied petitioner's motion for reconsideration in an order dated March 1997. The petitioner now seeks relief in this court. Petitioner claims that the point of higher classification employed by the school is discriminatory to Filipinos, and that the grant of higher salaries to foreign hires constitute discrimination. Now, the issues brought to the court was whether the salary differential between foreign hires and local hires violates the principle of equal pay for equal work and the equal protection clause. And the other issue was whether foreign hires should be included in the same bargaining unit as the local hires. As for the ruling, the court has granted the petition in part. Orders of the Dole Secretary upholding salary disparity were reversed and set aside. Foreign hires are also excluded from the bargaining unit with local hires. As for the equal pay for equal work, the court held that local hires and foreign hires perform the same work under similar condition, and there is a presumption that employees of equal rank perform equal work. If an employer accords employees the same position and rank, the presumption is that these employees perform equal work. The school contend that petitioner has not adduced evidence that local hires perform work equal to that of foreign hires. This presumption is borne by logic and human experience. If the employer pays one employee less than the rest, it is not that employee to explain why he receives less or why the other receives more. That would be adding insult to injury. The employer had discriminated against the employee. It's the employer to explain why the employee is treated unfairly. The school failed to provide as well. Oh, sorry. The school also failed to prove foreign hires were more efficient of effective to justify the 25 salary gap. Salary disparity continues. Discrimination and violates constitutional and labor law principles. Now, in regards with the bargaining unit, foreign hires and local hires cannot belong to the same bargaining unit. Distinction in tenure and benefits justify separate treatment. And also, collective bargaining histories also show that they were treated separately. Thus, the exclusion of foreign hires from the local hires bargaining unit is valid. The Constitution directs the state to promote equality of employment opportunities for all. Particularly in terms of wages, is frowned upon by labor code. The state has the right and duty to regulate the relations between labor and capital. The Constitution also enjoins the state to protect the rights of workers and promote their welfare, to afford labor full protection. These relations are not merely contractual but are so impressed with public interest that labor contracts, collective bargaining agreements included, must yield to the common good. Should such contracts contain stipulations that uh, should such contracts contain stipulations that are contrary to public policy, courts will not hesitate to strike down these stipulations. Now, moving on to the next topic, which is human rights. The Supreme Court stands as the guarantor of the constitutional and human rights of all persons within its jurisdiction and cannot abdicate its basic role under the Constitution that these rights be respected and enforced. Now, the Supreme Court is the highest protector of constitutional and human rights, thus, it cannot abandon its duty to ensure that these rights are respected and enforced. The Constitution requires that no person's life or liberty be taken without due process of law, even if someone is caught in flagrante delicto, meaning caught in the act of committing a crime, his rights remain protected, and the state cannot summarily execute individuals, as justice must always follow legal procedures. Well, an exception to this would be the act of self defense. If the suspect possess immediate unlawful aggression, officers may use reasonable means to prevent or repel the threat. Now, distinguishing natural rights between civil rights. As for natural rights are inherent to human beings, existing even before society or government and retained by the individuals after entering civil society. Uh, it is also the rights to freedom of expression and its various forms. These rights exist independently of the government. They are universal, or to say, the same all the world over, and depend on human personality and dignity. Individuals can exercise these rights without the government. However, the government has the role of protecting these natural rights. They become effective only when recognized and sanctioned by law, even though their existence does not depend on law. For civil rights, individuals enter into society and they surrender some natural rights to the collective in exchange for protection and order. These surrendered rights then become civil rights, which are guaranteed and enforced by the government. Rights that arise only within organized society and under civil government. So that's what civil right is. They are not inherent in human nature but are created to regulate and restrain government power. Examples of civil rights would be the rights to security, right to protection of property, right to equal treatment under the law, right to habeas corpus or protection against unlawful detention, and other rights guaranteed by constitution and laws that ensure fairness and accountability in governance. Now, civil rights are acquired rights. They exist only under civil government. They vary across countries and legal system, unlike natural rights, which are universal. Now, civil rights requires government action to be meaningful. For instance, the right to security is only real if the government enforces laws and maintains peace. They serve as mechanisms to check government power and ensure justice within society. As you can see here on the table, these are the distinction between natural rights and civil rights. For its origin, natural rights is inherent in human nature, whereas civil rights was created by civil society and law. As per universality, natural rights is universal, which to say that it's the same everywhere, whereas civil rights vary across states and governments. Uh, an example of these two are for natural rights. It includes rights to life, liberty, property, freedom of speech, religion, self defense, and whereas in civil rights, it includes the right to habeas corpus, trial by jury, constitutional protections, which varies from states and governments. Now, the natural rights' purpose is to enable human existence and dignity, whereas the purpose of civil rights is to restrain the government and ensures fairness in society. Now, although civil rights often incorporate natural rights into legal frameworks, they also include rights that are purely products of civil society. Together, they form the foundation of constitutional democracy. Natural rights protect individual dignity, while civil rights regulate the relationship between citizens and the state. Now, as for the case example and Aquino's thoughts on its ruling, uh, the Philippines had a before anything else. Um, let's start with the EDSA revolution. The Philippines had a revolutionary government without a formally operative constitution for about 1 month. This refers to the interregnum period between February 26, 1987, when Corazon Aquino took her oath as president after the EDSA People Power Revolution, and March 24, 1986, when the Freedom Constitution was adopted. The legal question at hand was, were Filipinos bereft of fundamental rights during this period, since the Bill of Rights was technically not enforced? In the case of Republic versus Sandigan Bayan 407 Scrat 10, July 21, 2003, the Supreme Court majority held that the Bill of Rights was not operative during the interregnum. Therefore, the private respondent Di Maano, or one of the private respondent in this case, Di Maano, could not invoke constitutional protections against the unreasonable search and seizure, nor the exclusionary rule, which bars illegally ob- illegally obtained evidence. As for Aquino's view in regards with this, in the book, Aquino expresses that he agrees with the result, but disagrees rather with the reasoning. He argued that even if the Bill of Rights was not formally operative, fundamental rights did not vanish. Rights like freedom from unreasonable search and seizures are not created by the Constitution, they are natural and inherent rights. The Constitution merely recognizes and protects them. Even in the absence of a constitution, individuals should still be able to invoke these rights. Aquino compares the legal dilemma to a theological analogy, asking whether Filipinos lost their rights during the interregnum is like asking whether the world was without God during the 3 days Christ descended into the dead before rising. Just as God's existence did not vanish, fundamental rights do not disappear simply because a constitution is temporarily absent. Aquino further invokes that the principle of nature abhors a vacuum, and so does the law, meant that law and rights cannot simply cease to exist. There must always be a framework protecting human dignity, even in extraordinary circumstances. Now, these rights set forth under the Bill of Rights, like the right to peaceably assemble, the right to freedom of the press and speech, the right to information on matters of public concern, and the right to due process. The term civil rights has been defined as referring to those rights that belong to every citizen of the state or country, or in a wider sense, to all its inhabitants and are not connected with the organization or administration of the government. They also include the rights of property, marriage, equal protection of the laws, freedom of contract, etc., or otherwise defined as civil rights are rights pertaining to a person by virtue of his citizenship in a state or community. Such term may also refer in its general sense to rights capable of being enforced or redressed in a civil action. Also, quite often mentioned are the guarantees against involuntary servitude, religious prosecution, unreasonable searches and seizures, and imprisonment for debt. Now, the concept of human rights emerged as a refurbished version of natural rights, emphasizing universality and moral authority beyond national laws. The usual the usual definition that it is the right which inherits in persons from the fact of their humanity seemingly begs the question. This definition is powerful but vague because it assumes that it seeks to prove that humanity itself confers rights. In the 1940s, after the devastation of World War II and the Holocaust, and the world rather sought a stronger framework to protect human dignity. The Universal Declaration of Human Rights in 1948 was culminated, which codified rights considered fundamental to all people regardless of nationality or culture. Like natural rights, human rights are derived from human nature, but their exact scope is debated since they are broad enough to encompass both natural rights and civil rights. Some rights are universally recognized, such as integrity of the person, um, where it be a protection from torture or arbitrary killing, equality before the law, religious toleration, freedom to dissent, and freedom from arbitrary punishment. Whereas not all rights are universally guaranteed, and an example of this rather is trial by jury, which is considered as a basic human right in the United States, but is not recognized as such in the Philippines. Uh, human rights, human rights legal recognition varies across jurisdiction. This shows that while human rights aspire to universality, their legal recognition varies across jurisdiction. Aside from the heavy American influence, the Constitution also bore traces of the Malolos Constitution, the German Constitution, the Constitution of the Republic of Spain, the Mexican Constitution, and the constitutions of several South American countries, and the English Unwritten Constitution. Though the Tidings-McDuffie Law mandate a republican constitution and the inclusion of a Bill of Rights, with or without such mandate, the Constitution would have nevertheless been republican because the Filipinos were satisfied with their experience of a republican government. A Bill of Rights would have nonetheless been also included because the people had been accustomed to the role of the Bill of Rights in the past organic acts. This only shows that the Philippines Constitution is both a product of global constitutional traditions and the people's own political journey. The
Equality before the law. Equal protection of the law means that all persons or things similarly situated should be treated alike, both in rights conferred and in responsibilities imposed. When we talk about equal protection of the laws, we mean that people who are in the same situation should be treated the same way, both in the rights they enjoy and the responsibilities they carry. Because equal protection, it ensures equality in the enjoyment of rights and privileges granted by law. It's basically about fairness. The law should not play favorites. Everyone, regardless of who they are, should enjoy the same protection and privileges if they are in similar circumstances. In simple terms, as the Constitution puts it, no person or class shall be deprived of same protection of laws enjoyed by others in the same place and in similar circumstances. So equality before the law doesn't mean everyone is the same. It means if we're in the same situation, the law should treat us equally. What equal protection requires and what is not. Now, what does equal protection actually require? The law requires that it must, number one, apply equally to all persons in similar circumstances. Number two, it requires to treat similar situations alike and different situations differently. Number 3, it also requires to provide the same protections and remedies to those similarly situated. Provide the same protection and remedies to those similarly situated. Well, the law must apply equally to all people in similar situations. If two people or two groups are in the same kind of circumstance, they should be treated the same way. But if they're in different circumstance, the law can treat them differently. That's fair. However, it's important also to remember what equal protection is not. Equal protection is not a guarantee of absolute equality. It does not mean that every man, woman, or child must be affected exactly the same by a law. It does not mean that all law must apply to everyone without distinction. It does not mean that different persons or things must be treated identically, even when their situations differ. It does not mean that equality of operations of law does not mean indiscriminate operation. It means equality according to circumstances. So it does not provide discrimination between things or persons that are actually different. For example, the law must treat minors differently from adults. So it does not mean absolute equality. It doesn't mean that every single person must be affected by a law in exactly the same way. We all have different situations, age, status, responsibilities, and the law can recognize those differences. For example, the law treats minors differently from adults. So that's not unfair. That's reasonable because minors need more protection. So equal protection isn't about forcing sameness. It's about making sure that when we make distinctions, they're based on real and justifiable reasons. Equality of the law means fairness that fits the situation. Now, let's talk about why equal protection exists. So here are the purpose of equal protection. Number 1 is to ensure fairness and justice in the application of laws. Next is to prevent unjust discrimination, favoritism, or privileges. And last is to ensure that classifications in laws are reasonable, not arbitrary or oppressive. Its main purpose is to ensure fairness and justice in how laws are applied. It prevents unfair discrimination, favoritism, or privilege. But at the same time, the law recognizes that people and situations aren't all the same, and that's where classifications comes in. Classification under equal protection. That's why the Equal Protection Clause allows classification because people and situations are not all the same. Classification in law means grouping persons or things based on shared characteristics that are relevant to the law's purpose. A law is not invalid just because it results in some inequality. The Constitution recognizes that some inequality is inevitable and acceptable. Classification simply means grouping people or things based on shared characteristics that are relevant to the law's purpose. So, not all differences are bad. What matters is whether those differences are meaningful to what the law is trying to achieve. A good example of that is driving laws. We don't let minors drive not because we're discriminating against them, but because the classification based on age and maturity serves the purpose of safety. And as the court said in Victoriano versus Elizalde Roof Workers Union, the guarantee of equal protection of the laws is not a guarantee of equality in the application of the laws upon all citizens. Equality of operation of statutes does not mean indiscriminate operation, but equality according to the circumstances surrounding them. Test for a valid classification. So how do we know if a classification is valid or not? The Supreme Court laid down 4 tests. Here are tests for a valid classification. A classification is valid if it meets these 4 requirements. Number 1, substantial distinctions. It must be based on real and meaningful differences and not imagined or trivial ones. Number 2, germane to the purpose of law, meaning the classification must be logically related to the law's objective. Third, not limited to the present conditions, meaning it must also apply to future conditions that are substantially similar. And last, 4, applies equally to all members of the class, meaning everyone who falls within the same class must be treated the same way. Here is also standard validity. The classification or distinction is valid if it, number 1, is based on reasonable foundation or rational basis, and second, is not arbitrary or oppressive. Meaning, if a law fails any of these, then it becomes unfair or arbitrary. In short, a valid classification has to rest on a reasonable basis. The law must have a logical reason for treating one group differently from another, not just personal or political views. Now, let's make it concrete with a real case. This is the case of Samer Overseas Placement Agency versus Baharo. Here's what happened. A group of Filipino workers were deployed to Taiwan under a 2-year contract, but after only 11 months, they were dismissed and sent home. They filed for illegal dismissal and other money claims. So the issue was this: under the Migrant Worker Act, there was a rule limiting back pay to just 3 months, even if your contract had many months left. So the question was, does the rule violate the Equal Protection Clause? So the Supreme Court said yes, it does. Why? Because it unfairly discriminates against overseas workers. Before this law, local and overseas workers were treated the same when it came to computing benefits. But with this new rule, OFW suddenly got less protection, and there was no valid reason for that. The court said equal protection allows classification, but only if it is reasonable. Here, in this case, OFWs and local fixed-term workers are in the same situation. Both have contracts with a fixed period. So treating OFWs worse was unfair and unconstitutional. The key takeaway is that inequality before the law means fairness in treatment. We cannot make one group suffer less protection unless there is a real and logical reason behind it. For our last case, Ormoc Sugar Central versus City of Ormoc. Here what's happened, the city passed an ordinance taxing all sugar produced by the Ormoc Sugar Company. At that time, Ormoc Sugar was the only sugar mill in the city, so effectively the tax applied only to them. The company challenged the ordinance, saying it violated the Equal Protection Clause, and the Supreme Court agreed. The ordinance was unconstitutional because it singled out one company. Even if there was only one sugar mill back then, the law should have been written in a way that applied to all sugar producers, including any that might open in the future. This case reminds us that for a classification to be valid, it has to meet the four valid test requirements. That it must be based on real distinctions. 2, germane the law's purpose. 3rd, not limited to current conditions but also apply to the future ones. And 4th, and must apply equally to everyone in the same class. The Ormoc Ordinance failed all those requirements, those 4 requirements. It was targeted only one company, and it's not fair. So, the big lesson here is that the power to classify under the law is not unlimited. It must be reasonable and not arbitrary. Equal protection demands fairness, and not just in intention but in actual application. In conclusion, equal protection ensures fairness and not sameness. And laws may classify, but classification must be reasonable.